What's up, everybody? It's Jason Cruz here once again with another episode of The Legal Submission. And this time we take a look at the Zuffa antitrust lawsuit and its petition to the Ninth Circuit Court of Appeals. It has received some backup from the U.S. Chambers of Commerce who have filed an Amicus curiae brief, friend of the court brief on behalf of Zuffa. Now, these briefs are mainly to support one side or the other or another side of a legal dispute or legal issue. And usually these things are filed. First, there's a motion that they have to bring to have the court actually entertain using that brief and legal citations and argument in determining whether or not to take the particular case. Now, amicus briefs are done on behalf of a group or someone with some sort of interest in the potential case occurring. And here we have the U.S. Chamber of Commerce, who's indicated that they also have been the subject of class action lawsuits and believe that the potential issue here is ripe for the Ninth Circuit to determine. And this relates mainly to the predominance issue in class action lawsuits. And what the U.S. Chamber of Commerce does in its amicus is argue that the way in which the plaintiffs, the ex-fighters in the UFC, came to their claim for damages was mainly cursory and did not identify the fact that there are potential people in the bout class of fighters that can file a lawsuit that actually have not been damaged. Now, this has been argued by Zuffa and the UFC, and here once again the U.S. Chambers of Commerce identifies this particular issue and how it would impact class action lawsuits. Now, there's two things that the U.S. Chamber of Commerce identifies in this briefing, and it's a shorter brief than what you get with the petition from the UFC. But again, with amicus briefs, they cannot. They have to bring up a new issue, and also, while it may support one side or the other, it has to have differing issues from what the Zuffa brief would include. So basically, it would have to add on rather than accumulate with the same arguments that Zuffa had brought in its petition. So basically, it has two factors. So going now back to Judge Boulware's order related to the element of predominance. He indicates and applies the law that in determining whether the common question prerequisite is met, a district court is limited to resolving whether the evidence establishes that a common question is capable of class-wide resolution, not whether the evidence in fact establishes that the plaintiff would win the trial. So again, we get to this bare minimum sort of argument, I like to think, where there's just to be a capability of class-wide resolution and that the predominant questions relate to the class and not the individual. And so even as Judge Boulware indicates, a district court cannot decline certification merely because it considers the plaintiff's evidence relating to the common question to be unpersuasive and unlikely to succeed in carrying the plaintiff's burden of proof on that issue. So again, we're not talking about proving your case at trial, we're talking about exceeding the threshold needed. And that is what Judge Boulware is doing. Now, compare that to the Chamber of Commerce's argument in their brief, which indicates that there needs to be more of a rigorous analysis, and that's where the district court failed in Olean. That's where the district court failed in this particular case, that there was not enough of a rigorous analysis. So therein lies the issue as to what defines a rigorous analysis by the court, and how do you resolve that with the Olean question that you need only establish the common question is capable of class-wide resolution. So here you got that push-pull. Chamber of Commerce and Zuffa want to overturn the Olean ruling at this time, and that is the big reason why you see support from the business community, because they don't want to deal with the class action lawsuits that can arise. Later on in the brief, Chamber of Commerce talks about how this would open up, as all lawyers like to hear, the floodgates of litigation. The fact that they like to depict that if a issue is resolved in one way, it creates a whole gamut of ways in which attorneys can sue and flood the courts with more litigation. Now, obviously, if there is, you would think if there is a truthful and reasonable complaint that courts would listen to it. However, the business community, in this particular instance, Chamber of Commerce, Zuffa, relate to the fact that they do not want to have instances where you can get through a piece of litigation in which plaintiffs are not injured. So therein lies the Chamber of Commerce's amicus curiae brief. Once again, the court actually has to accept that via motion before they take that into consideration when determining the issue on the petition. Now, again, as I've been airing this, the petition by the plaintiff's answering brief, excuse me, not the petition, but the plaintiff's answering brief to the petition, which will oppose the Ninth Circuit from hearing this, has actually been filed and is available, which we'll talk about next. But right now, this is the Chamber of Commerce's amicus curiae brief. I do assume that the court will take it under consideration when determining whether or not to hear this particular issue. If nothing else, it causes the question as to the Olean case and how they determined the predominance issue into question, and then potentially provides them some reason to take this question under consideration. So this is Jason Cruz with a legal submission. Like, subscribe, do everything you do. MMApayout.com. Thank you very much.